Thank you. Members, the floor is open for debate. I recognize the member for the 6th District, Honourable Myron Walwyn.
Madam Speaker, thank you very much for the opportunity to say a few words on the bill before us. Madam Speaker, I must tell you that I'm a little confused now in relation to the reason for bringing this bill. I know when you read a bill, you have what you call the objects and the reasons. That tells you why the bill is being brought. It is also very important to have the objects and reasons because sometimes in legislation, when you're trying to interpret the bill, there might be some ambiguity, talking 3-4 years down the road. And sometimes, whether it is the judge, whether it is defense counsel, whether it's prosecution, want to be able to make arguments to interpret what the intention of Parliament was at the material time. They go to the objects and reasons of the bill to assist with the interpretation. I am utterly confused. And I am even more suspicious now after hearing the presentation by the Premier. If you read the first paragraph of the objects and reasons, it says the Police Amendment Bill 2024 seeks to amend the Police Act, revised edition 2013, the Principal Act, to rectify certain deficiencies identified in the 4th round mutual evaluation report of the Caribbean Financial Action Task Force regarding the Virgin Islands. This legislation addresses directly the shortcomings highlighted on the Financial Action Task Force's Recommendation 31, including the need for statutory provisions for special investigative techniques, particularly witness statements, covert operations, and controlled deliveries. The bill, therefore, aims to align the jurisdiction's legal framework with international standards by addressing identified gaps, enhancing law enforcement effectiveness in investigating and prosecuting serious crimes, while safeguarding individual rights and ensuring necessary oversight and accountability. If you are saying that this came from the Caribbean Action Task Force, largely surrounding our financial services sector, the discussion and the areas that the Premier went into are diametrically opposed to the objects and reasons of the bill. So it raises questions as to what really the concern is, because the Premier went into areas of homicide and different things, all of a local nature. All of a local nature, so it tells you something different. I also want to clear something up, that nobody is against the bill. And I think the impression that was being given by the Premier is a wrong impression. And you really should apologize for it, because nobody has indicated that they are against the bill. Nobody indicated anything about afraid of the United Kingdom. Nobody indicated those things. If those are your views and you're afraid to say them, don't try to pass them off on anybody else. I believe they are your views, and you're deflecting them, but those are not the views of anybody, I believe, on the opposition, Madam Speaker. But, Madam Speaker, I want to make it lucidly clear that criminal activity has no place in this Virgin Islands. And we should all show our absolute contempt for any sort of criminal activity. Madam Speaker, but when you look at the bill, you have to always bear in mind balance, proportionality, justifiable reasons for what you do, to make sure that the appropriate checks and balances are in place. You shouldn't only just be concerned with catching people who may have done something wrong, who need to be caught. You have to also be concerned about innocent persons who could be affected if the appropriate checks and balances are not in place. And as I go through the bill, Madam Speaker, I'm going to show you convincingly how woefully inadequate this bill is as it relates, Madam Speaker, to the various protections. But I want to start off first by raising some preliminary concerns. When you look, for instance, Madam Speaker, at Section 35B and C, that deals with matters of evidence in criminal prosecution, it is basically putting on statutory footing things that already effectively happens right now. You take your witness statements, you have your audio, your video, you do all of that stuff, right? But Madam Speaker, we have something that is called the Evidence Act. We have something called the Evidence Act. The Evidence Act is intended to be a complete code on matters of evidence. That is what the Evidence Act is supposed to is for. And when you split up the code in this way, this bifurcation, I will call it, you create doubt and you create litigation. 35A and B should have been properly placed in the Evidence Act and not in this piece of legislation. I heard the Deputy Premier, and he tells the truth, that they didn't read the bill. And Madam Speaker, I know they didn't read them because we've been complaining about them not reading the bills all the time. But if it was one bill you were supposed to read, it would have been this one. Because if you don't go through it properly, if you don't raise the concerns, Madam Speaker, you put the very citizens who elected you to represent their interests in harm's way. Now, if you go to, for instance, 35C 13, it says the governor, in consultation with the commissioner and the director of public prosecutions, may make regulations respecting A, the procedure to be followed, the type of equipment to be used, and the arrangements to be made where a person is to use any audio or video recording medium. The governor, the commissioner, and the director of public prosecution, doing this. The types of photographs, screens, and support devices. Forms to be provided or submitted for the purposes of this part, and for such other matters as are necessary or expedient for giving effect to this section. Juxtapose this position, Madam Speaker, now with Schedule 3 of the Evidence Act. And I'll read out Section 3 of the Evidence Act. It deals, Madam Speaker, with the form of explanation in interviews. It tells you when, and this is for the person who is being interviewed. When you are interviewed by Dash, I made a record in writing of what you said and what was said to you in the interview. I made the record at the time of the interview as soon as practicable after the review. It is in English language that was used in the interview. I am now going to read to you in whatever language that you use in the interview. You can interrupt me at any time, blah, 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 and it goes on. This is what Schedule 3 says, which is ostensibly what you're giving to the commissioner and the director of public prosecution and the governor to do. But if you go on, Madam Speaker, and you also look at 84.8 of the Evidence Act, it says the Executive Council may, by order published in the Gazette, amend Schedule 3. So all you had to do, essentially, was go to Cabinet and amend Schedule 3 to include the things here that you want to amend in the Evidence Act. There was no need. What you're going to do is create problems. The very same thing that the AG chambers have been trying to do for years. Bring all the laws in the one area so you don't have them scattered all over the place. You're doing the same thing over again by putting this thing with evidence in the wrong place. That is the first error, Madam Speaker, that I've noticed with this. Now, when you look, Madam Speaker, at Part 3A of the bill, Special Investigative Techniques, 35A down to 35N of the bill. And I'm going to go through some of them at the appropriate time. The provisions do not, Madam Speaker, sufficiently secure the fundamental rights to privacy of the people of the Virgin Islands. It doesn't do it. If you go, Madam Speaker, to that section of the Constitution, that the Premier read out a portion of it, Section 19, the protection of private and family life and privacy of home and other property. Every person has the right to respect for his or her private and family life, his or her home or her correspondence, including business and professional communications, except with his or her own consent. No person shall be subjected to the search of his or her property, personal property, or the entry by others on the premises. And it goes on, Madam Speaker, to give you the various safeguards under which you can interfere. Because the rights to privacy is not an absolute right, it's a qualified right. And so it speaks about interests of defense, public safety, and other things. So the Constitution itself recognizes the fact that you have to have the appropriate mechanisms and safeguards in place when you are interfering with the fundamental rights and freedoms of citizens. And when you look at this act, Madam Speaker, there are not sufficient safeguards and controls in this. If you go to 38H, for instance, Madam Speaker, bear with me because I'm going to be referring to some notes from time to time. 38H speaks about authorization of covert operations. It says, and it raises a question as to what is meant by covert operations. What exactly do you mean by that? We know, yes, the ordinary meaning, covert, you're doing something and nobody knows that you're doing to them at the time. But what does it mean in the context, Madam Speaker, of this act? And it says, the authorizing authority may authorize covert operations for the purpose of A, gathering evidence of serious criminal behavior, B, the prevention, detection, or investigation of an offense related to money laundering, terrorist financing, or other financial crimes. And then it goes on to give you some other things which I will deal with at the appropriate time. I went and I looked for covert operations because the reason why they needed to read this bill was because if they read the bill, Madam Speaker, and did the appropriate research, juxtapose this bill with its sister bill in the UK, you would have seen how woefully inadequate the protections are in this bill vis-a-vis the bill in the UK. When you go and you look at covert operation, you look at a variety of things. Interception of communication. What that mean? Wiretapping and reading post. Use of communication data. Information about a communication, but not the content of that communication. Directed surveillance. Following people around the place. Human intelligence sources. Informers, undercover officers. Intrusive surveillance. Bugging people's houses and vehicles. That is the kind of thing you're talking about when you speak about covert operation. Those are serious intrusions, serious incursions on people's privacy. And yes, you want to solve crime. I understand that. And this is nothing new in other parts of the world. But other parts of the world also have the appropriate safeguards in there to protect and prevent abuse. And then when you look, for instance, now at serious crime. So it says the authorizing authority may authorize covert operations for the purpose of A, gathering information of serious criminal behavior. If you go to the interpretation, it says serious criminal behavior means behavior involving the commission of a serious crime. You go to serious offense. You go to serious offense, it says serious offense means an offense for which the penalty includes imprisonment of a term of more than 1 year. Can you imagine that? So a summary offense, pick one. Pick one. Honourable Fraser says hit somebody a slap. Depending on what it is, you might go to jail for a year. Depending on what the legislation says. How does that constitute a serious offense for the purposes of having people under covert surveillance? Doesn't that tell you that something is wrong with that? A summary matter. A summary matter, not even an indictable matter, a summary one. How could that make sense to anybody with sense? But then when you go now, because of the UK, and I'll come to it, they have a law called the Regulation of Investigative Powers Act, which is a counterpart to some of the things that are here. If you go and you read section 263 of it, they have a different definition. So the same people who tell you to bring this thing to the house, bring it, them fully well know that the laws that they have are different from what they're bringing to you. That's why you have to read the bill. So you could say, no, I cannot bring this because you're going to visit problems on my people. Section 263 says a serious offense, and this is a UK counterpart. A serious offense is one where the conduct involves the use of violence, results in substantial financial gain, or is by a large number of persons in pursuit of a common purpose. Violence, huge financial gain. Those are things that carry a long time in terms of imprisonment. But here it is now in our local legislation, you just simply say 1 year and that constitutes a serious crime. And we don't see, Madam Speaker, a problem with that. And then when you look, Madam Speaker, at (38H), I read that. If you go, Madam Speaker, now, to the interpretation of authorizing authority. That's on page 4 of the bill, which is another concern. Authorizing authority means the commissioner or a senior police officer designated as such. With all due respect, Madam Speaker, the Commissioner of Police and the Superintendent of Police cannot be the authorizing authority. It's just wrong. The police are the very ones carrying out the surveillance and carrying out the work. How can the person who is responsible for catching the criminals be the same person authorizing the operations? How? And that doesn't happen anywhere. I'll explain to you later on how it operates. It raises the question, I don't know how many of y'all are connoisseurs of Calypso, but when I read it, it reminded me of a song by a guy named King Austin. Who gonna guard the guards? Because if you have the police carrying out these operations, how can you have the Commissioner of Police being the authorizing authority? What sort of protection for human rights would there be? I'm not saying that the person in the position will be dishonest, but the appearance of it, it's wrong. You can't have that. And then, Madam Speaker, when you look, for instance, now at the electronic surveillance, I think it starts on page 9, Division 4. It says, electronic surveillance is only lawful if it has been authorized in accordance with this section. Subject to section 3838J, the electronic surveillance of persons may be authorized by the commissioner or deputy commissioner. In this section, referred to as the authorizing authority on application by a police officer of rank of inspector or above. An application to conduct electronic surveillance shall be submitted in writing or by such means as may be prescribed. The authorizing authority shall keep a written record of the application and the subsequent decision made under subsection 3. And then it says the application for authorization for electronic surveillance shall specify XYZ. If you go now, Madam Speaker, to 38J, the authorizing authority being the Deputy Commissioner of Police. They're giving him the authority under 38.1, under 38I. But then when you go to 38J, requirement for warrant for use of electronic surveillance. What are you saying really? You have two different regimes in the same bill. You are having the authorizing authority being the commissioner or the deputy commissioner, and then you're still saying that the requirement, the police officer authorized under section 3838I may, not shall, may apply to the magistrate or judge of the High Court to issue the warrant authorizing the use of electronic surveillance. So which one is it? Is it that the authorizing authority would allow you to just go ahead and do what you want? Or you have to end up actually go to a magistrate or a judge to get the warrant to do it? Which one is it? And you're saying that the police officer may, meaning once he gets his matching orders from the authorizing authority, who is his boss, he don't have to go to a judge or a magistrate to execute the warrant. But this is what this is saying. This is what this is saying. Then you look at 38. J3. That's on page 11. A warrant issued under subsection 2 may authorize one or more of the following: the use of electronic surveillance equipment by the police for the purpose of listening to or recording words spoken by or to any person while the person is in the vicinity of the item or person. And look at B. The entry onto premises by the police for the purposes of installing the electronic surveillance device or a part of the electronic surveillance device in or on the item on premises. Can you imagine? So the authorizing authority, who don't clearly, but based on this, don't have to study a magistrate or a judge, because this is what it says, can then go to your property when you're in home, because it's covert operations. They can't tell you to come in. They know you're going to work from 8 to 4, nobody in your house. They probably stake out to see when you're coming and when you're going, and then go in your house and put a device on your phone. Put a bug in your house. That's the BVI you want to live in? Without any safeguards at all, that can happen to any citizen? Because they believe that you're committing a serious offense, and the serious offense has to carry at least a year in prison? Is that the BVI we really want? So we are saying you want to capture criminals. We understand that. We all want to capture criminals. We don't want a criminal activity in the country. But you see how innocent people can get caught up? You see how you can create criminals out of ordinary, decent people? I don't think, Madam Speaker, that is something that we want at all for people. And if you go to the evidentiary provisions, Madam Speaker, and you look at 38K, it says, notwithstanding the Evidence Act, number 15 of 2006, any evidence relating to the details as to how a special investigative technique was carried out shall be admissible in court. Go down to 36K2. Information contained in a communication retained in a foreign state. 38K2. Yes. Information contained in a communication retained in a foreign state in accordance with the law of that foreign state and certified by a judicial officer of that foreign state to have been so intercepted and retained shall be admissible as evidence in proceedings for prosecution of a serious offense. People have to be aware of this kind of stuff. And so as part of, when this bill is passed, if it's passed, I can't support it in its current form, I have to tell you that. If we make the requisite changes and put the various safeguards in place, absolutely yes. But as it stands now, I have a problem with it. It exposes our people too much. But there has to be an education element to the bill, because essentially what they're saying here, if you go overseas and they call or discuss, they have an arrangement with their counterpart somewhere in the world, and you're using the telephone in the hotel room, they can bug that phone, and the information that is gathered from the conversation and that phone could be used here against you in criminal proceedings. That's what this is saying. This is some serious stuff. And so when the Premier gets up on the high horse trying to make his emotional spiel, he tells me, the man, you read the bill. The man, he don't understand what it is he's doing here. He doesn't understand the implication of this. He does not, because he didn't take the time to read it. I said, he wouldn't be talking the nonsense he's talking. I could say foolishness. Because that's what it is. When you're dealing with the lives of people, Madam Speaker, you have to pay attention. You have to pay attention, because there are some very, very serious implications. And then you go to 38L. protection from liability. Notwithstanding any other law, an authorized person who engages in conduct authorized under this part shall not be subject to criminal or civil liability for that conduct, even if such participation would, but for this part, constitute an offense. You understand what I just read? Notwithstanding any other law, an authorized person who engages in conduct authorized under this part shall not be subject to criminal or civil liability for that conduct, even if such participation would, but for this part, constitute an offense. So you go and you do something in a way that you should not do, which under normal circumstances would have been an offense. And the House of Assembly is being asked to overlook that in the interest of what you are doing. That is what the House of Assembly is for now? To make wrong right? That's what we're doing now? And then you look at subsection 2. Subsection 1 shall apply retrospectively to any participant in a covert operation or controlled delivery conduct prior to the commencement of this part, provided the requirements of section 38C in the case of controlled delivery, section 38H2 in the case of covert operations, or section 338I in the case of surveillance, electronic surveillance, could have been met had they been in force at the time. So you go under covert operation, you break in people's house, you go put your bug there and listen to them conversation. You put your bug on their devices. You do all kind of things you ain't gonna call doing. Don't mind your trespass on the stolen property because they can't know you're there. Right? And then we in this House of Assembly now must say, never mind what you do, man. We're gonna forgive you for that, and we must pass the law to say that. That is wrong. That is wrong, and this House of Assembly cannot be seen to be doing that. If you want to utilize these forms of investigatory powers or whatever you want to call them, activities, wait until the House of Assembly says it's okay to do so. When we pass the law and say it's okay to do so, then it is okay to do so. The job of this House of Assembly is to make and pass laws. It's not to clean up anything that you would have done that was wrong before. We can't be seen, Madam Speaker, to be doing those things. And then you run the risk of an offense being committed a while back, and you're waiting now for us to be able to say, you can go ahead and do it. And that way now, certain things can happen. I understand the objective, but you have to do, Madam Speaker, things in the right way. Now, Madam Speaker, this bill is, as I said, is devoid of structure and the proper procedures, Madam Speaker, in terms of protection of human rights. The UK, Madam Speaker, has what they call the Regulation of Investigatory Powers Act. The acronym is RIPA, 2000. And it was brought into force under Tony Blair. That's when the internet, back in the 2000s, when the internet was coming around and people didn't know how to react to certain things. And the UK's response was to bring RIPA into effect. They have a new act now they call Investigatory Powers Act of 2016. And Madam Speaker, to show you how I want to juxtapose it with that, because our human rights section, the right to privacy, is replicated from the Human Rights Act of 1998. Same provisions, same jurisprudence. the protection that they have in the UK, ours cannot be any less than what they have. We are people too. We are human beings too. We have the same fundamental rights and freedom as they have. And so the regime for the protection of our human rights must be the same as what they have in the United Kingdom. And what is here now, Madam Speaker, falls way below what they have currently in the UK. The authorizing authority under their act, which is RIPA, Madam Speaker, the authorizing authority is the Home Secretary, not the Police Commissioner, not the Deputy Commissioner. The Home Secretary is the authorizing authority. But it doesn't stop there. It doesn't stop there. The Home Secretary is the authorizing authority, as I said. But, Madam Speaker, there's an Investigatory Powers Commission. There's an Investigatory Powers Commission that before the Home Secretary authorizes the level of surveillance that we are talking about here, he or she must first get the approval of the Investigatory Powers Commission. And it is only in cases of emergency that the Home Secretary can then do something but get it ratified later on by the Investigatory Powers Commission. And to show you how serious they are with human rights, this commission is, anybody who go on the commission is made up of past judges of the UK. This is how serious they take the incursion on the rights of their people. There's also, Madam Speaker, an Investigatory Powers Tribunal. No such provisions here. So that if somebody goes into your house and do what it's supposed to do, there's a tribunal that has the responsibility who could quash whatever has been done. No such level of protection in our bill here, Madam Speaker, for our people. Are our people any less than anybody? We bite Christ? Are we any less? And Madam Speaker, I want to ask your indulgence to read something. Because the Premier should have done this. He should have done, why are you doing it? He should have done, so he could have not bring this bill here. So I went and I looked at the Home Office. And I read the Regulation of Investigatory Powers Act 2000. And there's a forward, Madam Speaker, a ministerial forward, from the Right Honourable Ben Wallace MP, who was the Minister of State for Security at the time. And he says, the Regulation of Investigatory Powers Act 2000 introduced a regulatory framework to govern the use of a number of investigatory covert techniques to ensure that the techniques are used by the public authorities in a way that is compliant with the right to privacy under Article 8 of the European Convention on Human Rights. This involves ensuring that the use of the powers is always closely supervised and constantly reassessed to ensure that what is being done is justified. The Act incorporated a number of important safeguards against the arbitrary or excessive use of the powers, including a strict authorization framework and provision for independent oversight. Independent oversight, the operative word. The Commissioner of Police cannot be deemed as independent because he is the boss of those people. Independent oversight and review of the use of those powers. It goes on, I'll skip a paragraph. But no, I shouldn't skip it, it's important. The powers themselves remain as important today as they were when RIPA was introduced, in that they are a vital tool to investigators seeking to prevent and detect crimes and to protect national security, public safety, and public health. Most recently, The Investigatory Powers Act 2016, which received the Royal Assent on the 29th of November 2016, will replace the powers in RIPA concerned with obtaining communications and data about communications with a new unified and coherent framework building on the structure already set out. The 2016 Act will radically overhaul the way these powers are authorized and overseen. It will introduce a double lock for the most intrusive powers, including interception and all of the bulk capabilities, so that warrants cannot be issued. Warrants cannot be issued until the decision to do so has been approved by a judicial commissioner. And it creates a powerful new investigatory powers commissioner to oversee how these powers are used. His final words, we are now taking this opportunity to update the codes that deal with the powers remaining under RIPA, which relate to covert surveillance, property interference, the use of covert human intelligence sources, and the investigation of electronic information. The updates are needed to reflect the changes in the 2016 Act, as well as to make a number of minor updates and clarifications intended to ensure that public authorities apply best practice in the use of their powers. This is what the Minister of State for Security, Madam Speaker, had to say. Now, when you look, for instance, now at 38J, that's page 10. A police officer authorized under Section 38I may apply to a magistrate or judge of the High Court to issue a warrant authorizing the use of electronic surveillance equipment in relation to a particular item or person. It says the magistrate or judge may issue a warrant if satisfied by information on oath, that A, there are reasonable grounds for suspecting that the item or person has been or is likely to be used in connection with the commission of a serious offense. B, the use by the police officer of an electronic surveillance equipment to listen to or record words spoken by or to persons in the vicinity of the item or person will or is likely to assist the police in or in connection with investigation that are being made in relation to the use or likely use of the item or person in connection with the commission of a serious offense. And C, obtaining some or all of the information by other means is not practicable or would be less effective. This is the basis, Madam Speaker, under which the magistrate can issue a warrant under the legislation that we have. Or we have before us, I should say. Just suppose that now, Madam Speaker, with RIPA, Section 2. It provides for specific things that must be considered in relation to issue or modification of a warrant. Namely, 1, whether what is sought to be achieved by the warrant, authorization, or notice could reasonably be achieved by other less intrusive means. So if you don't have to go through the things that you're going through, that has to be part of the test. If you can get the information you want without having to be as intrusive on the human rights of persons, then you shouldn't get the warrant. Whether the level of protection to be applied in relation to any obtaining of information by virtue of the warrant, authorization, or notice is higher because of the particular sensitivity of that information. Example, legal privilege or journalistic material. Because we have to also bear in mind that too. When you're getting permission to bug people's phone and so on, what about legal professional privilege? They might be getting advice from their lawyer. Where in this act there is protection for that? And then, of course, Madam Speaker, the public interest in the integrity and the security of telecommunication systems and postal services, and other aspects of public interest in the protection of privacy. So look at the four-pronged test that they use. Because you just can't give these warrants and these authorizations out, Madam Speaker, without making sure that they pass a particular test. And there's no such test, Madam Speaker, in the provisions of this bill. I mentioned a few things and I'll finish off, Madam Speaker, but I talked about, for instance, the judicial commissioners. And primarily, you should be of interest, this should be of interest to you. Their law provides for oversight by judicial commissioners appointed by the Prime Minister on the recommendation of the Chief Justice. So you're the Premier, you're even cutting your own self out of the equation. And the judicial commissioners, their job is to review, audit, and investigate the exercise of a statutory function by the police. The Investigatory Powers Commissioner sends an annual report to the Prime Minister. You ain't got a clue what's going on in this bill as the leader of the political leader of the country. And then you have an investigatory powers tribunal, and any and anybody on that tribunal. It is made up of former judges and senior lawyers. And their job is to consider and determine complaints and to quash or cancel any warrants. Now you go to 38M in our legislation. Go to 38M. At the end, the authorizing authority shall submit a report annually to the governor in such manner as the governor may determine. That's the extent of any protection we have. That is the extent. Compare this to that. The act is woefully inadequate in terms of its balance of protection of human rights in the country. And there's one last thing I want to put to you. One last thing. That's why it's important to read the thing then. There's something called the Wilson Doctrine. You ever heard about that? The Wilson Doctrine is incorporated in their law as well. And the Wilson Doctrine is a convention that restricts the tapping of the phones and so forth of members of Parliament in the UK. You can't tap their phones. Even the House of Lords, you can't tap their phones. That's the Wilson Doctrine. And portions of the Wilson Doctrine has been incorporated in their law in the UK. And in certain instances, if a member of the House of Lords or Commons has done something and the Home Secretary wants to authorize search, she advises the Prime Minister that this is being done. So there's protection in there for the highest lawmaking body. Think how you want about it. But that protection is there. Where is it inside here? I want to make sure that people who are committing criminal offenses in this country are caught and brought to justice, because we want a peaceful society. Their criminal activity threatens our very livelihood as we know it. But I also want to make sure that, one, they also have a fair trial because they have that right. And I also want to make sure that the fundamental rights and freedoms of the ordinary citizens are also protected. This bill here, this is nothing. It's a one-sided, lap-sided bill. And we have to, Madam Speaker, we have to in this House put the same level of protection for our people that exists in the Investigatory Powers Act in the UK. Our people deserve no less. And the provisions of the Human Rights Act, what is replicated in our Constitution, are exactly the same provisions. We shouldn't do any less for our people. Madam Speaker, as I said, I can't support the bill in its current form, but if the changes that I've recommended are accepted, I'll be in full support of it. Thank you, Madam Speaker.
Thank you.